Good afternoon, everyone, and welcome to Memorial's Technology Transfer and Commercialization Office Workshop Series. For those of you that have not met me yet, my name is Paula Mendonça. I'm Memorial's Director of Innovation and Entrepreneurship. I also lead the Technology Transfer and Commercialization Office, or TTCO. The TTCO is here to be a streamlined point of contact for the university to help move innovation forward from intellectual property education to research commercialization. We are also here to make collaborations between Memorial and industry move forward smoothly. If there are specific questions about Memorial's IP policy and how our office can help, please contact us. This session today will be a more general discussion about intellectual property with our guest. But before we start, I would like to recognize that we acknowledge that the lands on which Memorial University campuses are situated are in the traditional territories of diverse indigenous groups, and we acknowledge with respect the diverse histories and cultures of the Beothuk, Mi'kmaq, Innu, and Inuit of this province. Today, I would like to welcome Noel Courage, a Newfoundlander and Labradorian that happens to be also partner with Bearskin & Parr, a leading Canadian intellectual property law firm. Noel is a lawyer and a US and Canadian patent agent and was recognized in the 2021 Best Lawyers in Canada. Today, Noel will be talking to us about intellectual property and commercialization with a focus on engineering research and discoveries. With no further ado, Noel, welcome, and the floor is yours. And Noel, you're muted.
Might have your mute button.
Okay, thank you, Paul. I'm glad to be here. I appreciate Kara and you inviting me. And I'm going to get my PowerPoint up here, so bear with me for 1 second. Does that look okay?
Looks great.
So I appreciate the opportunity to be here. As Paula mentioned, I work with Bearskin & Parr. We're a law firm that focuses on intellectual property. I hope that nobody hung up after she said law firm and Toronto. I am a MUN alumni. I went to school at Dell, and then I caught the career virus, the Toronto variant. You know, it's very prevalent, like the Fort McMurray variant, where you go off in search of work somewhere else with a longing for home. But I'm glad to be able to work with people who are inventing products, developing brands in Newfoundland. And so today we're going to talk a bit about IP, high-level overview. First, we're going to talk about the types of IP, focus a little bit more on patents and patentability than other areas because it's a key type of IP. Talk about the interface of patents and value, a little bit about commercialization agreements and freedom to operate, and how to keep your IP investment ready. So IP, in the big picture, all types of IP have similar properties in that they're assets, like other types of property, like a car or something like that. You can buy it, sell it. You can give other people permission to use it. With IP, we talk about licensing it, and you can use it as security for a loan or other investment. And investors and grant funders these days are often looking at IP as a key way to decide whether to provide funding or invest. Another key aspect of IP is that it involves exclusivity. So you've come up with a new name, a new product, a new invention, and the IP gives you some exclusivity around that development that you've made. So very quickly, as I say, a high-level overview. There's plenty more about each, but we want you just have the key takeaway points. Trademarks are protecting product names, company names. That's basically your brand, like Coke or other products. Copyright, we'll talk a bit about that. Think of literary works, industrial designs. We'll talk about that as well. Appearances, trade secrets, keeping things on the down low, and patenting. So we'll get into each of these a little bit. Trademarks. A trademark is a brand or logo that distinguishes your goods or services from another company. So in the local tech scene, you may know of Instamar. So just the name Instamar is a word mark. You can have design marks, like Nike has a famous swoosh. Instamar has taken their word mark and put it with a bit of a logo. Of course, we know Fred's Records. And in the tech scene, you'll see lots of logos like the Bounce Health Innovation as a nice nice logo there with the DNA helix through it. All again, when you see these logos, you think of the organization behind it. There are also non-traditional trademarks, so sounds like the MGM Lion's roar at the start of a movie, or the Louboutin red is, since they're arguing that that's a trademark. There are a lot of things. If it's differentiating your products and services from another company, think about it as a potential trademark. You basically, as your cheap tip of the day, is that if you have a brand name for a product, whether it's a software or other product, mark it with a TM in your business plan, mark it with a TM in your promotional materials. If it's an unregistered trademark, mark it at the first occurrence. You don't need to mark every occurrence, but go ahead and mark that. And if you actually have it registered, then you can mark with an R in a circle. For copyright, we tend to think of copyright with artistic works and music, books, things like that. The one I want to highlight is software code. So software code, if you type up lines of code, just like if you type up the Great Newfoundland Novel, the software code is a literary work and it is protectable as copyright. Now, copyright is narrow protection. It basically will prevent people from cutting and pasting parts of your software code or your Great Newfoundland Novel, but it doesn't prevent people from copying the concept. So if you had a ride sharing service, as one example, you type up the code for that, somebody else could create a similar concept and compete with you if they type up their own code. Now, if they copy your code, then that's uh, a copyright infringement if they just take it. So it prevents reproduction. So copyright is good in that respect, but it is narrow in that it doesn't protect your concept. And we'll talk a bit more about copyright. Again, if you're having outside people writing text, doing drawings, developing code, things like that, you do need to be sure you have an agreement in place to own their IP, and this is a point that I'll be re-emphasizing. If you have copyright material, so just like I mentioned a couple of minutes ago, if you have a brand, you want to mark it with a TM if it's unregistered. If you have copyright materials, so your website, if you have drawings, other photos you're taking of your product, you can mark it as copyright. And one example on the screen, you can see in the bottom left that the Technology Transfer and Commercialization Office has that copyright notice. And you can use a similar notice, copyright 2021, Memorial University is theirs, and you would just put your company name in there. Industrial designs are another important type of IP. It is not directed to function, so again, it's a bit narrow. It focuses on shape. You have to register this one. So copyright and trademarks, you get a little bit of protection just by creating that brand and using it. With copyright, you get some protection by typing up that text or making that drawing. You get better protection if you register, but registration is not essential to create that little bit of IP in the first place. But again, you do want to register it. Industrial designs and patents, as we're going to see, you don't have anything until you register it. Now, designs, basically, we're talking about appearance, shape, things like that, not function. So a good example of an industrial design is Oakley sunglasses, where they're not saying necessarily that it's got a better light blocking ability, but it has a unique shape of the way the glasses go around, and they have all kinds of variants of that. That's an example of an industrial design where you're really protecting the appearance. Examples of industrial design. So I know we have a lot of tech people on the line today. So mechanical housing for electronics, if you have a nice looking housing, or if you have a cover for a piece of equipment, other things that you might not necessarily think of. For example, Uber has protected some of their graphical icons as industrial designs. So you can see it's a very simple registration. This is something that's been registered in Canada, but it's just basically a series of dots that are protected. Again, from the mundane, like on the bottom right, we have Microsoft's registered a plug connector, and at the upper right to the fun, things like joysticks. The part that's in dashed lines is not what they're saying their design is. They're saying the interior portion, which is in solid lines, is their design. So if you come up with something, it's got a really good look, then that is worth considering protecting its appearance as an industrial design. It will not have a broad scope, but it will be useful to prevent people from copying directly. Again, designs, you have to register them to have protection, and country by country as well. So you'd have to register in the US, Canada. If you don't register in Europe, you won't have protection there. So it really becomes a cost-benefit analysis as to where your major markets are, where your major competitors are doing business, these types of things. And again, it's a very flexible strategy. So if you, for example, are not able to commercialize in Asia, if you can find a licensee there who you can license a piece of IP to, maybe then they can take over the cost of filing for registration. So there's a lot of strategy involved, and you can follow up these types of questions with the Tech Transfer Office at MUN or other local organizations, or you can feel free to give me a call. So trade secrets. So probably all of you at the seminar have trade secrets. All R&D can start out as trade secrets just because you're keeping it under wraps. Whether your goal is journal publication or commercialization, it may be considered a trade secret. You don't have to register trade secrets. You have this right in the confidential information, it's a trade secret, until it becomes disclosed. So if you disclose it, whether through academic publication, through patent publication, through putting the product out there and other people can reverse engineer it, that will end the trade secret protection. So types of trade secrets, manufacturing know-how. It's often not justified to file patents on processes that tweak temperatures, hold times, etc. So manufacturing know-how, if you're making electronic components or devices, that kind of know as to how to make it efficiently can be a trade secret. If you're doing AI type inventions, algorithms, in some cases people try to patent processes based off algorithms, but often they're kept as trade secrets. So for example, if you're plugging search inputs into a Google search engine, that's a good example of a situation where you don't see the algorithms, but they're hard at work behind the scenes, and trade secrets are quite effective protection. Other people are free to make search engines, make their own algorithms. They can try to patent them if they want. But for Google, this has been a good approach for some of their algorithms. Chemical formulas, but not just technical aspects can be trade secrets. Business plans, customer lists, and marketing information could be trade secrets. There's many trade secret cases where an employee has left and taken a customer list. So all this to be trade secrets has to be treated a certain way. You must take steps to protect it confidentially. So if your customer list is just everyone in the company has access to it and it's not marked confidential, you're not taking the best practices to establish that that's a trade secret. And if one of your employees leaves, they may say, well, it wasn't a trade secret, it was information that's known, customers' addresses are public, you weren't treating it as a trade secret. So you want to take steps to limit access through physical barriers, through passwords, etc., and keep people on a need-to-know basis. That's an initial step to show that it's a trade secret. Again, as I mentioned, you do need to be able to keep the trade secret to rely on it because, like all secrets, they're vulnerable to public disclosure. Sometimes it's an accident. I've worked with companies that have had high-level executives go to financing forums and they're so excited about this new development that they talk about it. Well, that could be a public disclosure. Or social media feeds sometimes will show pictures of prototypes or talk about what they've got in the pipeline. So these sorts of things can really undermine the trade secret protection. If you have something you want to keep it secret, you need to treat it that way. You need to be sure as well that your employees and your collaborators are aware that it is a trade secret. Just one example, this is an area where an ounce of prevention is worth a pound of cure, but an example of a Canadian company that had a trade secret run-in not even 10 years ago is that the IMAX company, which makes those terrific movies where you're swooping around, very three-dimensional look where you feel encapsulated. So they had an employee that they believe took trade secrets for projection technologies and conversion technologies to convert, for example, 2D to 3D. They believed he took the software code and various other remastering technology, left the country, formed his own company that competed with IMAX. And if you don't spend this money on R&D and development work, and you just take the finished product, then of course you can underbid. So this just shows the damage that a trade secret theft can cause. And he won contracts, and there was litigation that resulted in Canada, the US, and China. The Canadian court granted a search and seizure order. They actually went to the person's home and they're able to search for um, information that had been taken from the company. The trade secret is a very sort of cloak and dagger type situation where there's somebody stalling the lawyer and the court officer at the door, and someone else was upstairs jamming a screwdriver into a laptop to destroy it. So it becomes, a very difficult situation on many levels to manage. And the IMAX did get a contempt order against an engineer, but part of the problems with Canadian court orders is that you have to enforce them, and it's not easy to enforce Canadian court orders against somebody who's out of Canada, and you end up with multi-jurisdictional litigation. You end up with spending a lot of company resources and money on it. So what could you do in this case? I'm sure there's a lot of lessons to be learned, but basically you kind of need to limit employees' access on a need-to-know basis. You need to be able to monitor what they're doing. You need to be able to control your information. And the technology to do this is getting better and better. Sorry. Just want to say a little bit about coordinating publications, because this is kind of where we're just talking about trade secrets, but at some point you have to decide whether to keep your trade secret under wraps or whether you're going to publish. And of course, the MUN Tech Transfer Office and the other groups at MUN want to encourage publication because it still, to a large extent, is a publisher-perish environment, but it can often coexist with IP protection. It's just a matter of coordinating the timing. So if you're thinking of developing something, if you're embarking on a course of research, if you're already there, a really good time to check in with the Technology Transfer Office is at the grant preparation stage. And you can talk about what you're doing, what resources are going into it, what you know about what's out there that other people have done, and what IP. Then you can have a discussion with the Tech Transfer Office about what IP could exist around your project. What's the scope of IP and the value? So the Tech Transfer Office can help assess what's out there already and what IP you might be generating, can help steer the project. If you see someone else is working in this area, then that's good to know academically because you might find something more novel if you shift a little bit in another direction, and you could be generating new IP. So you can do this initial assessment, figure out how to focus your research to develop more novel research, maybe develop some IP as well, which can be leveraged for drawing in additional research funds and commercialization proceeds. So again, it all kind of can work synergistically where you are developing publishable research results and maybe some IP as well. There's a lot of research that So a lot of work that goes into assessing what IP could be generated and the scope of it, but it's important to have the discussion early because once you've published, then that can impact your IP rights. You want to have these discussions early on to figure out how to focus your research, how to develop IP, what sort of useful data can support IP. And the Tech Transfer Office has really good resources available for that in Paula and Kara and other people who are working there. And you can really develop your IP focus. Even simple things like describing IP in the grant proposal. We often see that people will call a patentable invention something that they want to trademark. So that's why I emphasize the different categories, is that if you are developing a brand, that is a trademark. If you're developing a functional invention, that's probably more likely something you'd call patentable. If you're developing code, then you've got copyright in that code. So just getting the wording right for your grant proposal to show that you're IP savvy could make a better impact on grant reviewers. And the preliminary plan, getting that in place with check-in points. So you're applying for the grant. If you get the grant, when should you check in next with the Tech Transfer Office? When do you call in the IP lawyers like myself to do more formal and detailed assessments and parse fine issues like, is this system, which is AI based, we've added these aspects to it. There's sensors, there's outputs and manipulations of other equipment. Is this patentable? How would we go about patenting what's out there already? This sort of discussion is really important. Or if it's not the sort of thing you're going to patent, is there trade secret angle on the algorithms? Do you need to publish them? If you need to publish them, then let's talk about something else. So just getting these discussions underway early are really good to build a plan and build your confidence and to make a good impression on grant funders. Other resources at MUN, the MCE, CSE, and Bounce, all good resources, like whoever's handiest, you can ask them some initial questions. They'll direct you between each of them depending on where you are at the university, where you are in your R&D, what you're hoping to get out of it. They all have a slightly different focus, and you can find lots about them online, so keep them in mind. External resources too. The Canadian Patent Office has good information about IP on their website, and they do have designated people who can talk about IP. A good first step is the Tech Transfer Office at Paula and Cara. I would say that's a good place, but again, you have lots of resources to tap into. I'm going to talk about one more really interesting trade secret case just to really hammer home the importance of keeping things confidential. This involves the virtual reality headsets, types of things that are consumer products. There's all kinds of headsets that can put you in a virtual reality, but we're talking about the electronic ones here today. Sorry, I've gone off that one too quickly. But basically, in that case, Oculus was acquired by Facebook, and when the money flows is when you find IP disputes. So it's easy to gloss over the IP early on when you're doing R&D, but when the money flows, that's when you'll attract attention. And so Oculus was acquired by Facebook for several hundreds of millions of dollars, and that led to ZeniMax coming out saying, you know what, some of our former employees and a consultant went to Oculus, and we believe they took some of our trade secrets. And they had a litigation in the US. US litigation is often by jury trial rather than Canada, where it's a judge. And there was a judgment in favor of the ZeniMax company because the jury doesn't give reasons. They basically tick boxes saying what they find, but it's found that there was a breach of the non-disclosure agreement. So again, that's a key word that you should bear in mind if you're talking to other people who are research partners. If you've got employees, there should be a confidentiality agreement in place with employees, consultants, research partners, where they agree to keep your information confidential and that you own the IP. So ZeniMax company base was able to leverage their non-disclosure agreement to enforce their rights against Oculus and Facebook for taking this information. Back to the initial point about trade secrets, it's important to treat it like a trade secret, keep it confidential. You have to be able to show that you kept it as a trade secret, not that you were in free and loose with it, not that you did a whole bunch of publications on the internet about your information or a Kickstarter or any of this stuff that could undermine your trade secret protection. Now, there's a time for publications, there's a time for putting information out on the internet and for Kickstarter, but you just need to bear in mind to contact people who know about IP and figure out how to coordinate all that. Okay, a little bit of a deeper dive on patents. So to this point, just a quick recap, we've covered trademarks, which is your company logo or your product logo, your services logo. We've covered copyright, which is the right to prevent people from copying text, drawings, computer code, etc. Industrial designs, which protect appearance. We're all hoping to get our sunglasses out before too long. So the Oakley sunglass example is one I always mention. To the look of it, or your Nike sneakers, get them out and go for a jog. It can be protected by industrial design, talking about appearance. And patents are the type of IP that gets the most attention because they can provide broad protection. So like other IP, it's monopoly right, it's an exclusive right to use that IP. And here we're talking about inventions. So the better mousetrap, for example, protecting structure and function. Whether we're talking about if you come up with a new machine for doing 3D printing or printing more precisely, a method for printing more precisely, whether you have software-based invention, that may be the sort of thing that could be patented. Again, you often need expert advice because some types of software-based inventions, if they're mere data processing, may be difficult to patent, but other software where you have the software interacting with sensors and the like, or other outputs that are causing technical transformations, may be able to patent it. Key thing is, if you're developing something new, to just check in early on, have a discussion about it. Don't worry about parsing these types of issues yourself. Key thing for patents as well is, again, I mentioned before that it's important to coordinate the timing of public disclosures, whether through journal publications, poster publications, thesis publications. Coordinate that with the IP assessment and the cost benefit analysis, whether to get IP protection. Now, again, we want to definitely encourage publications. Students need to get their thesis out of there. Nobody's trying to put a lid on that. It's just a matter of coordinating the IP protection. So before you publicly disclose something, and publicly disclose is very broadly interpreted, putting it on the website, conference abstract that's published before the conference abstract, and upload to a database. These can all be things that affect your patent rights. Canada and the US are good. They'll give you a 1-year grace period after public disclosure, but other places like Europe will not give you will not give you a grace period, and you could eliminate your patent rights. And then it's too late to file, and you may have lost some of the potential IP that you could have protected. Again, patents are registered country by country, just like industrial designs. If you don't register, you don't have protection. So often the process will be that you need to get a patent filing date somewhere else. And then this is not something you need to concern yourself with today, but you can stagger filings in other countries. So if you file first, we often file first in the US or Canada, and then we'll look at filing in other countries a year later. And you can put more data into that filing at the 1-year point as well. It's very procedural. We're not going to get into it today, but the key thing is often to get a filing date, and then that's a basis to file internationally. And your term of protection with patents is typically about 20 years if you keep paying the annuities, and in some cases you can get an extension a bit beyond that, but it's a good scope of protection. 20 years is basically the monopoly that most governments give you in return for disclosing your invention. So that's the trade-off. You have to show other people through the patent filing how you make and use an invention. The patent filing is kept confidential for 18 months, but then it's published after that so other people can see what you've done, can make their own improvements, and science and engineering marches along. So in return for putting that knowledge out there, instead of keeping it a trade secret, you get this 20-year patent term. And that's key. That's why investors are interested in it. That's why we're talking about protecting more IP to give Canada an advantage over other countries. You spend all this money on R&D, all this time. You need to be able to protect it if you're going to commercialize it, because otherwise people just come along and copy it, and they don't have the R&D expense. And so just like in the IMAX example, they can underbid you, and then you're left to scramble a bit to try to protect your IP rights. And again, just because the IMAX, they did have trade secrets. IMAX does file for IP protection, but you don't want to be position where you haven't got protection or where you have to chase people with the protection. It's best to develop strong IP and really be on top of this situation and protect it. IMAX does a good job with its IP, but even people who are proactive and do a good job protecting it, sometimes you still have to enforce. Criteria for patentability. So just quick touchstones for you. To be patentable, it's got to be patentable subject matter. As I mentioned, if you're using an off-the-shelf AI product, you're feeding data in, getting a data output, then you're going to need to have a close look with the tech transfer office and your patent attorney as to whether you can patent it. Any software example of a software-based process, you're probably going to want to have a discussion with your patent attorney about the best way to focus that protection. Don't assume it's not patentable. Have a discussion with the people who've got experience with IP and see what their take on it is. And maybe they can find an angle. You often will be surprised as to what can be done to protect IP. So it's got to be the type of thing that can be patentable. It's got to be novel. And that often means that you have not published it more than a year before you file the patent application. If you published it 5 years ago, then if that publication is sufficient to show other people how to make and use the invention, the patent office will just say, here's something you published 5 years ago in a journal or on a website, and it's not novel anymore. Sorry. It might be a great invention, but it just, under our rules, it's not novel. It's got to be commercially useful, of course, and it's got to have inventiveness, which is another criteria. That's kind of a subtle point, is what you've done sufficient to be inventive. This is another area where it's good to get expert input, because often incremental improvements can be inventive. A lot of what scientists and engineers do is an incremental improvement. If you just change the screws to nuts and bolts, it's probably not inventive. But if you have done something which provides a functional advantage, makes it more cost effective to make, makes it last longer, then maybe there's something there that's inventive. So think about what are the problems with what other people have done and how have you overcome these problems. Take that to the tech transfer office, kick it around with them. There might be an angle for inventiveness. Scientists are often hard on themselves and engineers are hard on themselves when it comes to technology. They think, well, it wasn't a big deal. I just did it. I used my toolkit of knowledge and made this improvement. But the reality is, if it works better, if it's more efficient, if it saves costs, there might be something inventive there and there might be some IP. So that can be parsed and searches can be done to see what's out there already and to assess the inventiveness of it. And again, think about the big picture, not just the patents, but how do designs, trade secrets, trademarks, copyright all fit in with protection of the invention. Freedom to operate is another important issue to assess early on. And this is the point which you need to keep separate from patentability. So we're just talking about patentability is what I've done new and inventive. It's the type of thing that can be patented over what's out there. Freedom to operate is a different issue, and it's very easy to mix them up. Freedom to operate means, is there a patent out there which someone else has filed which covers what I have done? So if I was to pick an old technology like fiber optics, there's lots of patents out there that won't be a problem for freedom to operate because they're expired. But there could be newer patents which have some scope that your improvement could fall within that. So freedom to operate means assessing what's out there that other people had a monopoly on that's expired and not a barrier to you. It means assessing what do people have out there that could be a freedom to operate barrier and how do you deal with it. If you can patent your own invention, that does not give you freedom to operate. You could have a new and inventive product, but if it falls within someone else's patent because you've made an improvement, somebody made the base invention, you may still need to get a license from them or somehow figure out a way to design around their patent to establish freedom to operate. And freedom to operate, time consuming to do, very nuanced, meticulous, but the basic way to do it is to go out there and if you think Apple may have patents, you can search by keywords from the area generally. You can search under the name Apple to see what patents they have. And then you look at the claims, the numbered sentences in the patent, and see what is the scope of protection they have. Okay, so separate issue from patentability. Patentability, can I get a patent on my invention? Second, separate issue is regardless of whether I'm getting a patent or not, would making this product, would offering the service fall within someone else's patent? So keep these two concepts separate and they're both important. If you're doing a proposal about IP, if you're pitching investors, you need to be able to address them both and have a plan for both as to what you've looked at and how you plan to deal with it in the future. So again, just segueing from there into commercializing IP via patents. The quick recap again, we want to emphasize the key points to you, determining the full scope of the invention and how you could vary it, and what scope of patent could you get? Can you protect your key invention? Can you protect it broadly enough that there's value there? Does the invention justify the cost of patenting, which can be if you file internationally, it can be tens of thousands of dollars over several years, or it could be hundreds of thousands of dollars if you take a very aggressive international patent filing strategy. And the numbers can be daunting for patenting, but the key thing is it's not that expensive to file a first patent application, and you can try to find investors, licensees, etc., to help offset some of the costs. This is part of what the Tech Transfer Office and other organizations that help with tech transfer can assist you with. You may have filed an IP, you may have filed a trademark, a patent. Again, it's important to revisit the cost-benefit analysis. Are you still using that IP? No. Well, maybe you should consider abandoning it, not spending more money on it. If competitors might want to use it, maybe you could license it for a fee, or maybe you would keep it as a freedom to operate barrier for that competitor. So cost-benefit analysis is important in IP. Don't be afraid to cut your lines and move on. Determining inventorship is very important for IP, and you need to know who the inventors are, and you need to secure ownership before people are doing coding, before people are doing bench work or design work with you, before you hire contractors or contract research organizations. You need to have an agreement in place to secure ownership. So know going in who are likely to be the inventors, who uh, is going to be generating IP, and secure their ownership. And sometimes if you are overseeing the work and making suggestions, you may not actually be an inventor. So if you're suggesting to somebody to go solve a problem, you may not be an inventor. You may not be an inventor on the patent application, but if you have the agreement in place ahead of time, then you may still own that invention, or you're not doing the coding. But because you have agreement in place, you can still be an owner of that code for the app or the product. But you have to deal with these issues as early on as you can. Again, as far as if you're going to file patent applications or design registrations or trademark applications, know when to do that, do it early on, and have a plan as well for freedom to operate. Have a bit of analysis done and a plan for how to address freedom to operate issues because investors will ask you about this. So just a quick example of IP in motion. This is a glucose meter. So if you are measuring blood sugar, for example, somebody who has diabetes, you need to measure your blood sugar. What you do is you prick your finger, put a blood sample on a strip. It's not just a piece of paper, it's a very specialized type of strip. You feed it into the glucose meter and it will tell you what your blood sugar is. You can figure out if you need to take more insulin, less insulin. And these are very common devices, and there's a lot of IP around these devices. And as you'll see, this includes all the types of IP we've been talking about: trademarks, copyrights, trade secrets, patents, and industrial designs. So as we go through these, think about your own products and services and what IP might be protectable there. So as the initial type of IP, if the Bayer company launched this product, they have their own company name protected. It's a very well-known company, and the trademark Contour for their diagnostic instruments. They protect it broader than just saying a glucose meter. They talk about diagnostic instruments just because they want a broader scope of protection. You do have to specify what you are protecting it for. You just don't get rights over everything, but you do try to protect the brand names in your field. Copyright. So if you go to the website, there's software for protecting it. So the website, the, the drawings, photographs, text about frequently asked questions, all that can be protected by copyright. If there's software, the code we discussed, the graphical icons can be subject to copyright in some cases, as well as industrial designs. Your marketing materials. So, and you can see that the contour is marked with the R in the circle, indicating that it's a trademark, like we talked about for trademarks. So good practice here, and I'm sure there's a copyright notice in there somewhere as well too. So this is all your IP. It's not your most critical IP, things like the drawings or the text, but things like software code, that could be very critical to supporting the device and getting patient adoption. So a lot of important IP here. Industrial designs. So if we go back and quickly look at the device, it's kind of a nice looking device. You wouldn't think there's anything that's sophisticated about it in the appearance. It's a few buttons. It's designed to be simple with a few buttons, just so people can operate it easily. If you think patients are often a bit older and maybe a bit less tech savvy, so you want it to be simple, but you want tech to be simple for any user. The appearance of it matches what was commercialized, so this would prevent somebody from adopting this exact same design for a knockoff. So this is a good example of industrial designs protecting appearance. They don't talk about the way it functions, it's just the design. And patents as well. So a fair bit of patenting around it, and patents are quite complicated as far as how they're written, but basically you write up what it is that yours improvement in a claim or a series of claims, and you'd say basically we have a biosensor, and in this case the patent would be directed to having a conductive layer on a support which reduces background reactions reduces background reactions, conductivity, and gets rid of signal noise. So the claims are focused on this substance that provides for better operation of the device. And you could have a whole load of patents around this type of device. A key aspect would be establishing that what you have is new and inventive compared to what's out there already. But patents are important. They protect the function of the device. Trade secrets. So if you think about this device, again, the technology, you have chemistry in how the strips operate. It's not easy to make the strips. You have to have a high level of quality control. You have aspects about how you make the device efficiently, and the how the code is working that's embedded into it. Also aspects about who your customers are and who you sell to can be trade secrets. So all these sorts of things could be trade secrets. Your risks as to keeping it a trade secret as opposed to patenting it, our competitors can reverse engineer. They'll take your device and take it apart, see how it works. Your employees, if they breach confidentiality, that's a risk. Or if there's some accidental disclosure. So these are all risks to keeping a trade secret. So it becomes a cost-benefit analysis and a risk assessment analysis, whether to file a patent or keep a trade secret. But for everything that's a trade secret, you do want to go through that analysis saying, well, it's a temperature setting, it's a chemical treatment, it's a method of manufacturing, it's a minor algorithm. You want to go through the process of analyzing whether it meets the threshold to justify patenting. If you don't patent something and a competitor does, then the competitor can still get valid patent rights because you've kept it a secret. So that's part of the assessment as well. Key things arising out of what we've been talking about. So a theme that I've been repeating is to be proactive. That's what it all adds up to, is proactive IP management. Develop your initial design on a confidential basis and test it. You don't need a prototype to consider patenting. You do need to be able to describe the invention in enough detail that other people could make something like it. File a patent application if you're going to, if it meets the patentability criteria and you can get a good enough scope of invention and it's commercially important enough to justify the costs, then you file your patent application that describes not just the invention, but all the ways you can think of to vary it that can be reasonably shown or predicted from the patent application. Then, after you file a patent application, if you're going to do that, you can publish, disclose, put the thesis out there. Sequence here is important. To assess the IP, coordinate the IP with the publications. Once you have the IP strategy and the publication strategy lined up, and before you actually even launch them, you may be looking for potential partners. You may want to file a patent before you approach the partners. You may not. This is something you'll work out with your IP strategist. But from there, you look for funding, etc. And as you make improvements, this is an important thing too. People often think, well, I filed a patent, I'm covered. But you'll make improvements that are more effective, work better, cheaper to manufacture, etc. Some of that may be improvement IP that you want to protect. So keep IP in mind as you go along further with the research, because you often want to file to protect your best way. Your most commercially important products may justify their own patent filing. In contrast to the in contrast to the proactive IP, we have reactive IP management, which is as soon as you come up with an idea, publish it, post it online, tell the world, put it on Kickstarter, etc. So that can cause problems, and then you're scrambling to protect the IP after the publication. So again, we're not trying to stop publication, but it's just a matter of assessing whether you want to file IP at all. If you don't want to file IP, that's fine, that's your prerogative. If you have no interest in commercialization, you just decide you want to publish, that's great too. I mean, it's all important contributions. But you do need to be proactive, not reactive, if you're going to protect IP. Another thing to keep in mind is if you file a very narrowly worded document as a patent application, it can be very easy for people to design around it. So you do need to protect your invention and its variants, or protect your trademark broadly. These sorts of things are important. I've talked a little bit about agreements. I just want to quickly mention the types of agreements. We're not going to go into them today, but just to say what they are, because you will encounter these in your navigation of the commercialization and IP world if you choose to go that way. And in fact, even if you are interested in academics, you may find research partners pushing these agreements out to you. Even if a commercial partner is going to take the invention and commercialize it, and you just are happy to do your research, you still need to know what they're putting in front of you. Assignment agreements transfer ownership. So if somebody is giving you an agreement called an assignment agreement, then they're trying to transfer ownership. Confidentiality agreements keep things confidential. It's very obvious from the name of it. Now, as a academic researcher, how broad is that agreement? Is this going to impede and prevent you from doing publications of your own work if you're working with a research partner? Is it going to constrain you? So you kind of need to know what you're required to keep confidential before you sign one of these in someone else's favor. If you're getting other people that work with you and you want to develop IP, then you need to be sure that they're obligated to keep confidentiality. Collaborative research agreements basically are documents that set out the project and how it's going to go. Timelines, budgets, etc. Also, it will talk about who owns IP and who's obligated to keep what confidential for how long. So look for the assignment and confidentiality agreements embedded in your collaborative research agreement. Material transfer agreements, if you've got materials, if you've developed a chip of some sort, or if you developed something else, which is a battery, and you're giving a sample to someone else, you want a material transfer agreement so that people can't reverse engineer it, so they can't give it to other people. It's a type of confidentiality agreement. If you're working with a commercial partner, whether for development or commercialization, you may give them a license. So if you own the IP, or if Mun owns the IP, you may be giving the partner a license to use the technology, which means a permission. And so you need to carefully craft that, not just sign a really broad license, which gives away too much. And many other types of agreements you'll encounter: distribution agreements, supply agreements, manufacturing agreements. Bottom line being is that all these agreements, if they're dealing with your IP, you need to make sure that they are broad to protect you if you're the IP owner. If you are not the IP owner and you're doing research with someone else, you need to know what they're trying to protect themselves and how that could affect you and potentially encumber you. So these agreements, it's important to get a legal review. Mun has people who sometimes, if you're working with the university, can review. If not, there are plenty of good corporate lawyers locally who can do it on a cost-effective basis. I think we've got at least one or two on this call. And my firm also can review these agreements for you. The main thing is to just know what you're signing in advance before you sign it, and to get the research agreements or whatever agreement is you've got, to get it in place before the work starts, whether it's for an employee, a contractor, arm's length research partner, organization. You want to have the agreements in place before you start the work. It's very hard to get the agreements in place later on. Even if you're just getting someone doing coding for you, if you are having somebody develop something for a 3D print, who is going to own the IP? You want to have the agreement in place for that early on. Again, as I mentioned earlier too, if you're the one driving the ship, you want to own it. You may not be an owner of copyright if you have someone else do all the coding. You may not be an inventor if you're giving people suggestions and they're the ones solving the problems and you're just making a mere suggestion. If you're in there developing, putting a lot of intellectual input into it, you may be an inventor. But the bottom line is you have to worry about these sorts of issues and technicalities less if you have the agreements in place early on so that you're protected. Put a little bit more in about this just to say what collaboration agreements are for, but I want to get to the Q&A. But basically, have agreements in place, and this is your rule book for working with other people. Signing without reading, that one speaks for itself. Read the example I've got here when you get the slides. Don't sign away too much. And control of collaborators. So, an interesting case, this one bears a brief mention. Glaxo, which developed the AZT compound for treating HIV infections, they provided their compounds to NIH on a blinded basis. NIH didn't know what they were testing. NIH gave some results, put them back to Glaxo. Glaxo was the sole inventor of that. They didn't invent the compound, they developed the use for treating HIV. But the NIH, they collaborated with a way where they did the minimum amount of research with the NIH as possible, in the sense that Glaxo was doing all the developing, NIH ran a proprietary assay, Glaxo retained all its IP. So it's an interesting one in that if you are Glaxo, if you're the IP owner, you want to control the IP tightly, to own as much of it as you can. If you're NIH, if what you're doing has value, you want to have the agreement reflect that, so that maybe, okay, I'm not going to be an inventor on this patent filing, but I want to get some compensation for it in some other way, because you can have a contractual arrangement to pay somebody for the work they're doing, regardless of whether they're an inventor. It's these concepts, you kind of have to keep them separate in your mind. This issue went all the way to the Supreme Court, with NIH saying we were inventors, and it was found out that they were not inventors. So takeaway point is to think how a collaboration agreement up front would have or could have addressed this issue. I'm sure they had an agreement in place, but the collaboration agreement, if NIH has expectations, if Glaxo has expectations, you can get that all in your collaboration agreement up front. If you leave it till afterwards, it could be too late and you can end up in a disagreement about it. So agreements, very important. Get them in place early, make them comprehensive. Keeping ready for investor due diligence. Important for startup companies, okay? Because somebody may come in and they want to know about your product. You can talk about your product for days, but then they'll ask about your IP, and it can become a scramble to get it all organized. It doesn't make a great impression, but also it can become a pain point for you to get this information together. So whatever is your IP, whether it's trademarks, patents, industrial designs, trade secrets, etc., you want to have a list of it. You want to be able to enumerate it. You want to be able to explain what it is, what you believe is patentable about it, why it's strong, to show that you've secured ownership. If you have people doing software development, if you've had somebody doing 3D print development work on it, to develop files, things like that, you need to establish ownership of it. If somebody did design work and then 3D printed it, or if they had intellectual input into the code development or the app development, you need to show that you've got ownership secured. And you do that through your agreements in place before the collaboration starts. With IP, you want to be able to explain, as I said, the quality of it. Not just that you have a lot of it, but you do have good quality IP that gives you a place where you have exclusive rights compared to competitors. You want to also be able to explain your freedom to operate, that you don't believe you infringe any other people's patents, that you have the rights to use the software. If you have open source software, for example, that you've developed, you need to trace back the licenses and show that you can carry on using that. And be prepared to articulate your future plans for IP. So what IP do you hope to create with the funding, whether it's grant funding from a grant agency, whether it's funding if you're getting a postdoc or a PhD student in for a MyTax grant, what IP are you generating and what's the value of it? Or for investors, they'll be asking this all the time. So go easy on yourself, have your IP cataloged according to the points in this slide, and you'll find it easier when it comes to grant writing time. It'll be one less thing to pull your hair about, or if you're dealing with investors, you'll be ready to go and you can focus on the merits of your product or service and not so much about filling in IP gaps. IP assets, so coming back to this point, we led with this point. Think of IP as an asset. People often think of IP as something you go and sue other people with. That's not really what we're going for in most cases. We don't want to sue people. We want to license the IP or sell the IP. We want to build a company around the IP. So think of IP as an asset, not just a sword. If you have to sue people, you have to be prepared to stand behind it. If you can establish the strong IP position, then you're ready to stand behind it. There's issues around cost of IP enforcement for startup companies, but basically you have to deal with that when it comes. You may have partners that can help offset the cost. If you're affiliated with a big institution, maybe they can help offset some of the costs. And just to show full circle on the glucose meter example, the way that ended up is that Panasonic bought that business from Bayer for $1 billion. Sounds like a huge amount of money when I think about when I put this part of the slides together, seemed massive to me, but then I think about what happened in St. John's with Verafin lately, and maybe it's chump change. I don't know. You decide. uh, so the sky can be the limit, but what you're buying here, I mean, some of what they're buying is non-IP, like you're getting a business and people. When you get that, they did get the trademark contour. They are rebranding under Essentia Diabetes Care. The rebrand is done now, but the patents, the trademarks, the trade secrets, the copyrights, that's a lot of what you're buying. I mean, you're buying manufacturing facilities and all that too, but a big part of the value there is the IP. So we're not all aiming for a billion-dollar business, and to grow that business, to exit that business, whatever. We all have different goals. There have been successful exits in Newfoundland, even in the past few months, for tens of millions of dollars. So uh, whether you want to keep building your business, whether you want to build a business, you can exit. The IP is an important component, and you've got lots of resources around you to help protect your business. So I would encourage you to take advantage of the resources that you have. Mentioned a number of them, but the tech transfer office is a good starting point. But again, the other groups on campus can be a great help. Even if you're not doing healthcare, for example, you could go ask Bounce. They would steer you to the tech transfer office, to an Angel Group, whatever. Great resources. Just whatever your issue is, pick one of their brains. They are all very helpful people and will get you pointed in the right direction. So that's the presentation, and thank you all for attending. It's been great speaking with you today. If you know anybody in the Faculty of Science who is interested in IP, we're going to be having another more science focus for the chemists and the biochemists and the geography and the physicists, so they don't feel too left out. Similar principles to this, so if you're a science person and you've come today, welcome. And you feel free to spread the word about our next seminar. And again, tap into the resources you have available to you on campus. My contact information is there. You can call me anytime. I'm happy to speak about general IP issues, and quite often I'll steer you back to the local resources in town. If you have an agreement, I'll steer you to a local lawyer, or I can steer you to the tech transfer office at MUN, wherever. Just call anyone you know who's involved in IP, and they'll get you pointed in the right direction. So with that, I'll pass it back to Paula and Kara, and John Duff is helping us with the logistics here too, so you may see his name. Thank you, John, as well. And thank you, Paula, Kara, and Mun for having me here today.
Thank you, Noel. This was excellent. And I know we only have 1 minute for questions, but I see, so I'm just going to jump right into it because we had so much great information. And Courtney has a question about if there is requirements either in Canada or US patent law that an assignee must be represented by a registered practitioner when initiating or engaging in a license agreement.
No, you should have a lawyer review your license agreement, but there's no requirement to have one. We're going to do this Family Feud style. We're going to do short snapper, so fire away, and maybe we can get through these and follow up with questions to any of us.
Yeah, absolutely. And that's what I was going to say. If there was anything else, just let us know. Any other questions? I'm not seeing other ones here in the Q&A right now. I have a quick question as well. I know it's 2 o'clock and I'm very cognizant of people's times. When is the sweet spot to file a patent? We talk about the proactive, the reactive. When is kind of like the sweet spot?
So if it's a very competitive industry, I would say that you may need to go a little early before you generate the data, but you do need to have the invention so that if it's mechanical invention, for example, to draw it up, but you have to be able to explain it in enough detail for other people to make and use the invention. You don't have to build a prototype. You don't have to build the software. You do have to show other people how to make and use it, and you do have to be able to emphasize the point of inventiveness. That's the point at which they should go to your office, have a chat with you. We'll have a discussion about it and when to file. If it's a very competitive industry, we may go a bit sooner. If it's an area where we feel like we have a bit more time, or it's a bit speculative, like we're not sure that we can soundly predict, then we may say, okay, let's generate a bit of data and circle back in 3 months, 6 months.
Thank you, Noel. That's great. Any other questions? I know we're a little bit over time, so I'm gonna leave it like that for now. Some thank you there. This was extremely helpful, Noel, like so many good tidbits of information. I also appreciate the case studies because you can have a clear picture of how this concepts can be all together. Like Noel was saying, we are going to have a session specific for science in the coming months. So look out for that. We'll do, you'll see that on social media, and will be sent also to the different units. If you have any questions in the meantime so far, please let us know. Just contact Noel, contact our office. We're here to help out. And also thank you, John, on the technical side to making sure that this session runs smoothly. And Noel, thank you so much again for accepting our invite to come and talk to Memorial.
My pleasure. And later this year or next year, we'll do it again in person. If people from Toronto are allowed in, we'll have to see how that goes. It's maybe people from Newfoundland may like this a bit too much. We'll have to see.
Thank you very much.
Thank you.